Hi, I'm Steve Christie and welcome to Speaking for the Unborn. This 4-part video is designed to accompany this book, Speaking for the Unborn, 30-second pro-life rebuttals to pro-choice arguments. Now, originally I wanted to call this presentation Pro-Life 101. It seemed a rather gentle and inviting title, but the reality is the most accurate title for this talk should be Abortion 101, even though it sounds so harsh and off-putting. The fact is this presentation is everything you need to know about abortion, that is, the truth about abortion, so that you can help put an end to it. And once you know the truth, you'll be ready to share it with others. Now, let's briefly mention the objectives of this talk. We'll discuss why we raise this issue at all, the law, the current state of affairs, the science, that is, embryology, the actual abortion procedures themselves, 5 facts about Planned Parenthood, strategies for our mission, how to actually speak for the unborn, that is, the words we actually use, and lastly, what you can do to help the pro-life movement. So we'll be discussing the facts or the truth about abortion, and then we'll briefly talk about the apologetics or the defense of that truth. So why should we raise this issue at all? Because since Roe v. Wade in 1973, there have been over 61 million abortions in the United States alone. Now, if what's being aborted is not alive or not human, then it really doesn't matter. But if those abortions are of living human beings, then we've killed over 61 million children. That's why we raise the issue. Now to the law, beginning with Hippocrates, the father of modern medicine, whose oath for all physicians declares, "I will keep my life and my profession pure and holy, and will abstain from inducing an abortion." Sadly, an astonishing 89% of medical schools now omit this part of the oath. Next up, our country's foundational documents. The Declaration of Independence makes clear our very first foundational right, the right to life itself. And note, by the way, this is not a right given to us by the government, but from our, quote, Creator. Moreover, this right cannot be taken away. We say this right is unalienable. And the role of government is simply to secure these unalienable rights given to us by our Creator. Similarly, our Constitution affirms this most fundamental right, the right to life itself. Now for a mini primer on constitutional law. To be an effective advocate for the unborn, there are only 3 Supreme Court cases you need to be familiar with, and we'll focus only on the basics here. They are Griswold versus Connecticut in 1965, Roe v. Wade in 1973, and Planned Parenthood versus Casey in 1992. Griswold is famous for declaring that a right to privacy exists in the Constitution. And where exactly in the document was this right to privacy found? Well, the court searched the Constitution thoroughly and found the word privacy was located exactly nowhere in the document. For good or for bad, the fact is that privacy is never even mentioned in the Constitution. So then, where exactly did the court find this right to privacy? Well, they found this powerful right in penumbras. Now, if you're a bit embarrassed that you don't know exactly what a penumbra is, you can relax, because precisely no one knows what a penumbra is. Even the dictionary offers little help. The partially shaded outer region of the shadow cast by an opaque object, which of course should make you ask the very focused question, huh? Yes, apparently the court found this fundamental right to privacy in shades and shadows and opacities. Now, I've thought long and hard how to best explain to you how penumbras give rise to a constitutional right to privacy, and really the best way I can describe it is this. Ta-da! It's magic. It's pulling a rabbit from a hat. Next up, we have Roe v. Wade. Roe held first that Griswold's right to privacy includes the right of a woman to abort her child. Secondly, Roe held that at viability, that is, when a baby can potentially live outside the uterus, which the court said was at 28 weeks, states can restrict or even prohibit abortion, except when it's necessary to preserve the life or the health of the mother, which we'll talk about in a minute. Lastly, the court said that a fetus is not a person, and therefore is not accorded the rights of persons enumerated in the Constitution. Now, before moving on, I want to focus a minute on these 2 exceptions that preserve a right to abortion after viability, those exceptions for the life and the health of the mother. So what is this preserving the life of the mother after fetal viability? Well, it's a fiction. There's never a situation where abortion is required to save the life of the mother after viability. It's always faster to deliver a living baby than it is to abort that baby. A 3rd trimester abortion, as we'll learn later in this talk, takes 2 to 3 days to perform. A delivery takes only hours. And what about preserving the health of the mother after viability? Well, This is an unlimited exception. Why? Because of a case decided the very same day as Roe, a case called Doe v. Bolton, which held that health includes, quote, emotional well-being. So if a woman feels distressed at any time during her pregnancy, even near the end of her pregnancy, she qualifies for an abortion, which makes this exception an unlimited one. And this makes Griswold and Roe what I call the double whammy. Now, the last Supreme Court case we have to discuss is Planned Parenthood versus Casey in 1992. Here, the court affirmed Roe's right to abortion and said that before viability, a state may not place a, quote, undue burden on a woman's decision to abort. After viability, they followed Roe's lead with those same exceptions for the life and the health of the mother. And what exactly is an undue burden? The court gave a definition that's still unclear today. They said it's any substantial obstacle in the path of a woman seeking an abortion of a non-viable fetus. Lastly, the court also declared that viability was now at 23 or 24 weeks instead of 28 weeks due to advances in medical care for newborns. And Casey's the case where Justice Anthony Kennedy famously declared, "At the heart of liberty is the right to define one's own concept of existence, one's own concept of the meaning of the universe, and one's own understanding of the mystery of human life." This, of course, is the very definition of what we call moral relativism, the notion that we're all entitled to our own facts and our own truths, that in this case, there's no scientific or objective definition of life. And as we'll discuss in a few minutes, such an approach to basic science and basic morality is both unscientific and objectively immoral. And this faulty reasoning leads to what I call the abortion trifecta: Griswold, Roe, and Casey establishing a nearly unlimited right to abortion at any time for any reason. And what about the legal cases after Casey? Well, they've mostly centered on the question of what exactly constitutes this undue burden. Can abortionists be required to have nearby hospital admitting privileges? Can abortion centers be required to meet the safety standards of surgical centers? Can a state require a fetal ultrasound prior to an abortion? Or what about waiting periods? Are these all undue burdens under Casey? Now, I'd like to say just a few words about what's called constitutional adjudication, which is just a fancy way of saying how constitutional rulings set legal standards for all future cases. And the key term here is precedent, which says a rule established in a legal case is binding on all future cases that have similar issues or similar facts. And to visualize this principle, this is the best analogy I can come up with. This is what precedent is supposed to look like: a solid foundation of case law that builds upon itself, case after case, layer after layer, ultimately creating a pillar of stable, reliable, practical, and most importantly, defensible jurisprudence. But if precedent is binding on all subsequent cases, why do we sometimes hear talk about overturning laws? And why, for example, during Senate confirmation hearings of judges, do we always hear Roe is precedent, and Roe is super precedent, whatever that means, and now Roe is precedent on precedent? And by the way, I fully expect to soon hear Roe is superty-duperty extra special hands-off, don't you dare, extra mega ginormous precedent on precedent. Which of course starts you thinking, maybe Roe's precedent's not so very strong after all. The fact is there are clearly established criteria for overturning precedent. And while we don't need to memorize them, we should be aware they exist. Criteria such as reassessment of the quality of reasoning, or a change in the understanding of relevant facts. And the court has repeatedly held that bad precedent is no precedent. And thank God, or else blacks would not be citizens of the United States, and racial segregation laws for public facilities will be the rule of law in this country. So if this is solid defensible precedent, what exactly does abortion precedent look like? Well, I think it looks something like this, just a wee bit shaky. Griswold finding a right to privacy in penumbras, Roe extending this right to include the killing of a child, and Casey telling us that everyone is entitled to their own definition of life. Well, this ends our discussion about abortion and the law. Now let's briefly talk about the current state of affairs regarding abortion in this country. Back in 1992, Bill Clinton famously summarized the pro-choice movement's opinion on abortion. He told the world that abortion should be safe, legal, and rare, acknowledging the seriousness and the sadness that abortion involved. Well, those days are long gone. Over the past 10 years or so, the pro-choice movement's mantra about abortion has become anytime, for any reason, and for free. And now, of course, you're supposed to shout your abortion because it's apparently something to celebrate. You can even attend shout your abortion parties and pose with fun props. And like these two women, you can be giddy with excitement as you proudly celebrate the death of your unborn child. You can even now proudly wear your abortion dress. Note, machine wash in cold water, tumble dry on low heat, it says here. And today you can actually put your child in an I Love Abortion t-shirt. By the way, I thought for sure this was a fake image, but it's a real website where you can outfit your young kids, and sadly, this young boy will have to live with this repugnant image for the rest of his life. And let's be clear, abortion advocates are not just those secular or non-religious folks. Here, for example, are three words that should never go together: Catholic, Mother's Day, and abortion. So this is a problem that's now pervasive outside and inside the religious world, which of course then begs the question, how did we ever get from safe, legal, and rare to shouting your abortion? Well, I think the best way to explain it is with those three famous monkeys: see no evil, hear no evil, and speak no evil. About 50 years ago, the sexual revolution took root and sought to unmoor sex from marriage and family. They told us that sex outside of marriage was liberating and empowering and wonderful and completely without consequence. Shockingly, it turns out there were some rather serious consequences, not the least of which was a surge in unwanted pregnancies outside the safety net of marriage, which left those sexual revolutionaries only two options. One, they could admit the experiment backfired and return to traditional values, or two, they could just, well, get rid of those darn pregnancies. And we know exactly which choice they picked, because sex, sexual identity, sexual self-expression, and now sexual fluidity are the hallmarks of today's modern secular culture. And the only way to get rid of those darn pregnancies was to pretend they didn't exist, to deny the very truth of their being, to be blind to the truth, to be deaf to the truth, and to never, ever speak the truth. And tragically, we've learned what happens when society maintains this denial for a generation or two. We actually lose sight of the truth entirely. And this leads precisely to where we are today, a culture of death, where we are blind to the truth, where this baby, seen at 20 weeks by MRI, is called a mere clump of cells by the pro-choice movement. Note how remarkably baby-like this clump of cells is. Obviously, we're looking at a baby that any 4-year-old could properly identify. And while you watch this video, please bear in mind that in every state of this country, an abortionist is permitted to stick in a pair of forceps and tear off the limbs of this child. And we are deaf to the truth. Again, any 4-year-old listening to this knows exactly what they're hearing. And in case you're not sure, you can actually watch the 4-chambered heart in action. But just this past year, the New York Times shamefully argued that this, of course, is merely, quote, embryonic pulsations. And lastly, we dare not speak the truth. The pro-choice movement survives on rhetorical deception, and the audacity of their efforts would be comical if it wasn't so tragic. Where living unborn children are only products of conception or embryonic tissue, and where violently ending the lives of these unborn children is merely, quote, reproductive health care. Where clinicians at Planned Parenthood ask desperate and frightened young women, would you like us to restore your period? Where abortionists who violently end the lives of the unborn and then scrape them from their mother's wombs describe their noble actions this way: I safely and efficiently emptied the uterine cavity, rendering the woman unpregnant. This intentional rhetorical deception knows no boundaries, but we all know the truth because it's now perfectly visible to anyone who wishes to see it. And if you're still unsure, I'll give you a hint. It rhymes with maybe, wears diapers, and requires a lot of wipies. Go ahead, you can say it with me. It's, of course, it's a baby. Now, I was only going to include this one photo because this talk is already too long, but then I came across this one and I just couldn't resist. And then, well, this guy just killed me. And because my wife and I have an adopted daughter from China, well, I just couldn't resist adding these twins. And then these guys, who are clearly going to be linebackers for Notre Dame. And then, and I promise this is the last one. Now, I'm not a twin, but if I was, this would clearly have been me. I'll now end part one of this talk with a reminder of what our job is. It's to open those eyes, to open ears, and to speak the truth, which ultimately is to open hearts. This ends part one of this talk. Thanks for your kind attention.